Hello everyone, this is Robert Mansour. I'm a lawyer in the Los Angeles area, and today we're going to discuss how to administer a living trust, also called trust administration. Basically, we always get calls in our office about someone who is the trustee of their family's trust, and their mother or father dies, and now they find themselves as the trustee, and they don't have the first clue as to how to get things going and what they should be doing. So we decided to create this video to cover many of the different things that occur during a trust administration. All of my contact information is located on the screen. You can call our office for more information at 661-414-7100, or you can visit the website at www.mansourlaw.com. Now, this information is being provided to give you a general overview of what needs to be done in many cases involving the handling of a living trust. But of course, the caveat at the bottom of the screen, always consult with a legal professional and financial professionals, including tax professionals, when handling this kind of thing, because if you make a wrong move here or there, it could end up costing you and your family quite a bit. So let's begin. First, we're going to start with a basic overview of trust administration, and basically these are the big bullet points that we're going to cover. Number one, please understand there are rarely any emergencies. Sometimes I get calls from clients who are on their way to the funeral home or going to the service, and they say, what should I be doing? What should I be doing? And I tell them, you don't need to do anything. Just calm down, grieve for your family, gather with everybody, remember the person who passed away fondly, and the only thing you might want to do is get death certificates. That's really the only major thing, and depending on how many assets you think your loved one had, you might want to order between 10 or 15 death certificates. If you knew that your loved one had lots of different assets, lots of bank accounts, lots of real estate, then probably order 15 or so, and if it's on the lower side, order about 10. The reason you want to order the death certificates early in the process from the mortuary is because oftentimes it is much easier to do it that way. If you try to get them later, it can take a very long time. It could take many weeks before you see anything from the county. The number two thing you're going to be doing as trustee is you're going to be locating all of the estate assets. This is a difficult thing to do, and it's not always that easy. You basically have to figure out, what did this person have before they died? What assets did they have? What bank accounts did they have? What real estate did they have? What other kinds of accounts like IRAs and 401ks? And did they have a pension of some sort? Did they have life insurance policies? Did they have any CDs at some banks? Checking accounts, savings account, bonds. Sometimes you'll find stock certificates. This is the part I call taking inventory. Basically, you're going to try to collect all of the assets, and sometimes that's not so hard to do, and sometimes that is hard to do. And how do you do it? Basically, you have to figure out, did they have any kind of system at home where they put all the information? Is there any information in the living trust itself? Sometimes there will be a schedule of assets somewhere in that binder. Sometimes you just have to keep your eye on the mailbox, and the mailbox becomes your friend because every month you might discover a new account that you didn't even know about. So you got to spend the first, basically month or two collecting all the assets and trying to figure out what they are. And keep an open mind that you might discover more as the weeks and months go on. The next thing you're going to be doing as trustee is you're going to be paying the debts of the estate. People just can't die and not owe any money to anybody. That's not how it works. They might owe money. They might owe credit card debt. They might owe a mortgage. They might owe a promissory note. They might owe a loan, second mortgage. Who knows what it is. But the point is that you have to try to identify all of the loans and all of the debts, anything that is owed money, medical bills, for example. Those kinds of things. Try to take stock of all that, make a very good list of everything that is owed. And the final thing you're going to be doing as the trustee is distributing the remainder to the beneficiaries, which is the last thing you see there on the screen. So we'll get to all of these things and probably more as we go on. The next question I always get is, what should I be doing with all the personal property? What do I do with all the stuff that's in the house? Here's the thing. Number one, make sure people don't start taking stuff. You see, there is this phenomenon that occurs when people die. People just start to come to the house and take stuff. Their aunts, uncles, cousins, sons, daughters, they just walk in and they start lifting stuff and putting it in their car. A vase, a painting. Sometimes you'll see a family member make off with an entire vehicle. I don't understand the need to do that. It's kind of like vultures descending upon the house. If you have to, as trustee, you can go ahead and change the locks in order to protect all the stuff in the house, because all of that is typically part of the estate. So what you want to do, if you don't need to change the locks, is see if there are any special gifts. Usually there's a place in the estate plan somewhere in the binder where the person can indicate any special gifts they want someone to have. So for example, they might say, all of my jewelry to my niece Mary, all of my baseball card collection to my nephew Michael. You know, things like that. See if there's any special instructions in the binder itself, in the estate planning binder, the living trust, all of the documents. If there are none, the decedent may have left some kind of system where they wrote on the back of items and they put a name like, you know, Bobby. They put that on the back of a vase or on the bottom of the vase. So their intention is to make sure that Bobby gets that vase. So make sure that there is no system or no special gifts, and if there are, you're going to have to take care of those as trustee. But that's not just, you don't just hand those things out. The best thing to do is to give those special gifts away at the appropriate time, and we'll discuss that later. And then you have to also see, what does the trust say about the personal property? In most living trusts, there is a section that deals with personal property, and it addresses what's supposed to be done. And sometimes you'll see something that says, all of my personal assets are to be liquidated and all the money divided. Well, then you can't just start giving stuff away, can you? Because the trust says that you're supposed to liquidate everything and add it to the pot and distribute the money. So you can imagine, if you give away something of value, one of the beneficiaries might not be terribly excited about that because you were supposed to sell that item. So be very careful about what you do with personal property. Don't just start giving things out without taking inventory and without taking a look at the documents and seeing what they say about that. The next thing you should do, and these are not necessarily in the order that you should do them, but secure a tax ID number for the estate. Secure a tax ID number for the estate. That means that you can't use the social security number of the decedent anymore. That person passed away, and once they pass away, you can't use their social security anymore. So a tax ID number is essentially a social security number for the estate. Sometimes it's called an EIN number. EIN stands for Employment Identification Number. And again, all of these things mean the same thing. It's a tax ID number for the estate. Because here's the thing. A lot of the money and the investments and the things of that nature are going to be sitting in accounts, and they might be earning interest, dividends. It might not be a whole heck of a lot, but there might be something going on. And all of that's going to go on for several weeks and sometimes several months. And so the tax ID number is important when it comes time to report taxes. The CPA has to file a tax return on behalf of the estate. And the CPA is not going to use the person's social security number. They're going to use the tax ID number from the date of death forward. And basically, you can get to this form by contacting your CPA and asking them to get one for you. You can contact your lawyer if you're working with one and say, hey, listen, I want to get me a tax ID number. And then you can also call the IRS and get one from them. They'll put you on the phone and they'll ask you lots of questions, but you'll get one eventually. Another consideration for the trustee is whether to do a formal or informal approach to the administration of the trust. So here's the thing. From a legal point of view, there's a lot of formalities that go into administering a living trust. The probate code says what to do step by step. However, if there's only one beneficiary and that's you, there's really no reason to go through all these formalities. If there are two beneficiaries, brother and a sister or two siblings, and everybody gets along really, really, really well, and there are no in-laws who are going to cause a trouble, sons-in-laws, daughters-in-laws, maybe you can do this thing much more informally. You don't have to do it all by the book. But if you do it by the book, you've got to send something called a 120-day notice to the heirs and to the beneficiaries. 120-day notice. This is a letter that goes to the beneficiaries and to the heirs, and it says, hey, listen, I'm the trustee, this is my address, this is my phone number, this is the person who passed away. Here is a copy of the living trust. In most cases, you want to provide them with a copy of the trust because they're entitled to it. And if you have any problems with the trust or you have any challenges to the trust, you have 120 days to bring that challenge. If they don't do anything in that 120 days and there's no challenge, then they get cut off from bringing any further challenges, which is kind of a nice way to kind of move things along. Plus, at the very bottom of this notice, you can include a waiver, a place where they will sign that they waive the 120 days. Now, why is that important? That's important because if everybody signs that, then you can move along much more quickly with the trust administration. You don't have to wait the 120 days. And most of the time, if people are going to get some money, they're going to sign. It doesn't always happen, but and this notice has to be sent currently, at least according to the current law, within 60 days of the death. And I always like to include a copy of the trust because if you don't, the clock doesn't start ticking until they get one. Well, the clock can restart ticking, and that's not what you want. So just go ahead and send it to them. There's no need to hide the ball. One last thing about that, by the way, is that if you do provide, the trust, it shows that you're being forthcoming. You're not trying to be mysterious about your handling of the trust. You're being upfront, and that's really important because the beneficiaries start to get concerned. They start to, worry that there's some monkey business going on. Not in all families, but sometimes. Next is the issue of how to handle all the bills of the estate. Now remember, you're going to try to figure out what the bills are, and that could take some time. And then you're going to want to make a list. How many are there? Are these even legitimate? Sometimes they're bogus. Sometimes they've already been paid. And you want to make sure they're legitimate. The next thing is you want to notify all of the debt holders and all the people who are owed money, the creditors. You want to notify them of the death. Sometimes you can do that by letter, or you can just give them a call. You basically say, hey, this person passed away. Here's a copy of their death certificate. Thank you very much. Now, the reason I tell you this is because in some cases the creditors will basically forgive the debt. There are some credit card companies that if the amount is small enough, they're going to forget about it. They're going to send you a letter saying, thank you, Mr. Smith. Thank you for notifying us of the death of your dad or your mom, and we have closed the account. The balance is zero. Now, that doesn't necessarily mean everybody's going to do that, but it's nice if some do. Then you're going to find out which companies and which entities are insisting on repayment. So once you've notified them of the death, you're going to find out, well, who is insisting on getting paid. And you have to understand, you're going to pay them from the assets of the estate. You don't pay them from your own pocket. Some of these places will try to get you to believe that you are liable for the debts of the decedent. In most cases, unless that's your husband or your wife, you are not responsible for those debts. They are not yours, but they belong to the estate. So you have to establish priorities and make sure that the ones that are most important get the most attention, and the ones that are least important get the least attention. In many cases, you want to negotiate the debt, if you want to. Now, some people are against this, but I don't see why not. So if you call the debt holder and say, hey, listen, I know we owe you $1,000, but would you accept $500 if I sent you a check tomorrow? You see, they have to have incentive, too. You can't just negotiate with them and they have no idea when they're going to get their money. Tell them, and you might want to tell them the reason why. You might want to say, look, there's not a lot of money. We're trying to get everybody paid, and here's what we can offer you. And many times you'll be surprised that they will go ahead and accept the lower amount in exchange for getting paid more quickly. But you don't want to get rid of everything in the trust because you want to retain some in the pot for taxes, because Uncle Sam is not going to be happy if you owe taxes and you don't pay them because you gave all the money away. That's not going to look real good. Another issue that sometimes pops up is what to do with respect to nursing home expenses and other medical expenses that happen and are incurred and you receive them in the mail. First, find out what they are. Again, collect and analyze. Another issue that is interesting is you have to ask yourself, well, has insurance paid their share? Sometimes you're going to get a bill, but it's not really the bill. In other words, the insurance company hasn't even responded to the bill, so you're not even sure whether or not they've paid anything or not. So you want to make sure the insurance company, the health insurance company in this case, or Medicare or Medi-Cal, for example, has paid the bill. Sometimes you're going to get the bill too early, and the insurance companies sometimes take a very long time to respond to these bills. So you want to make sure that that money is actually owed. And of course, you ask yourself, how much remains to be paid? You ask yourself, how much remains to be paid, and can I negotiate that? And I will say a good 75% of the time, you'll be able to negotiate those bills. If there were any Medi-Cal benefits, these are state benefits paid by the state, Medi-Cal, you should notify the Department of Health Services in Sacramento. Send them a letter. Say, hey, Department of Health Services, so-and-so passed away. Here's a copy of their death certificate, and this is their social security number. My name is so-and-so, the trustee of the estate. Please let me know if there's any money owed. Now, the reason this is a good letter is because you're going to get a letter back from Medi-Cal telling you how much you owe. And it's not you personally. The estate owes the money. And this is where people freak out because they're like, oh no, we're going to lose everything to the government. Well, not necessarily. The government lien might not be as high as you think it is. And again, they may negotiate with you. You never know. And if you don't owe any money to the government, you can take this step by notifying health services. And the reason is you're going to get a letter from the Department of Health Services saying, thank you, you don't owe any money to the state. And now you have this wonderful letter that you can keep in your file that says you don't owe any money, which is a kind of a nice thing to have. Next in your list of things to do is you want to collect and find out all the different bank accounts and investments that the person had. Find out how, the first thing you need to do is you have to take a look at how title was held. So you have to actually look at the statement and see what appears on the statement. Is it just the individual's name? Is it the name of the trust? Is it jointly owned with somebody? And so what you do is you go to the bank and you take the trust document with you and the death certificate and your ID because you're the successor trustee. And you walk in, and if the asset was in the name of the trust, they're going to basically put you on as the trustee of the Smith Family Trust, for example. Instead of the person who passed away, they're going to remove that person and they're going to put you, and you're going to be in charge. After that, you can do whatever you need to do with that account because you're on title as the trustee. Now, sometimes they might require you to sign something called an Affidavit of Death, which is just something where you declare under penalty of perjury that this person passed away, and this is a copy of their death certificate. Another thing you want to look out for is any accounts that are held jointly. So you go to the bank and you find that your mom or your dad or whoever you're handling the estate for owned that particular account jointly with somebody else. Basically, with joint ownership, last man standing or last woman standing gets the entire account. So that being the case, they're going to take off the name of the decedent, and the remaining person owns the entire account. There's really not much more to it. You don't have to administer that. That's not part of the trust. It just passes outside of the trust, if you will. Now, that can be a little bit awkward because that person could be you, or it could be just one of the siblings, and we have to figure out, well, gee, is that fair? But then again, from a legal standpoint, it has nothing to do with fair. If your name was on the account as an owner, that's your account. Another thing that you can take a look at is some of these accounts have a payable on death designation or a transfer on death designation. What that really means is essentially that when the person opened the account, they already filled out a form that says this account goes to so-and-so when I die. And it's just a beneficiary. And again, that passes outside the trust. The beneficiary trumps whatever the living trust says, just like joint ownership trumps anything that the living trust might say. Finally, if you have a couple of accounts sitting in a bank and they were the only things that weren't in the trust, and this happens a lot. People will have living trusts and all of the assets are in the name of the trust, but they might have one or two small accounts sitting outside the trust. You might be able to do this thing called an Affidavit of Small Estate. And this is basically something that essentially says, hey, this person passed away, they didn't have a large estate, they had a small estate. At the time of this recording, in California, anything under 150,000 would qualify. And that number can, of course, change as the years go on. So make sure you check on that. But basically, you fill out this affidavit. Sometimes the bank will have one for you. You don't actually have to get one prepared, but a bank will actually have it. And then just fill it out, notarize it, sign it, and in most cases, they'll give you the account. That doesn't always work as well as it sounds and as easy as it sounds, because there are some banks that are just going to give you a hard time. These are called difficult banks, and there's, just like any other financial institutions or any other institutions period, there's always going to be the ones that give you a hard time. And there's very little that we can do about those people and those institutions except keep trying. Appeal to a higher authority, talk to a supervisor, go up the food chain if they continue to give you a hard time. Another issue that crops up a lot is this issue of safe deposit boxes. Now, I never understood the wisdom of having a safe deposit box, but a lot of folks, especially older generations, seem to really like it. And it's basically a box at the bank with a key, and you keep important stuff in it. And the problem is that most of the time, nobody else has a key. And then people die and nobody can get into the box, and this is very, very frustrating. But you should also check this out. Probate Code Section 330 allows the trustee with a key, that's important, you have to have a key, you can't just walk in, to access the safe deposit box for purposes of making inventory and removing estate planning documents. If the content of the inventory suggests a low value of the box's contents, then perhaps you can use the small estate affidavit that I was talking about before. So basically, it's kind of an art, if you will. You go into the bank, if they won't let you in, tell them about Probate Code Section 330. It allows you to check it out, to open the box, but you have to have a key. And then you're only allowed to look at the inventory of the box, remove the estate planning documents. Some of them will insist that you make a copy and put it back in. But if after looking in the box you realize, gee, there's not really much of any value in here, I could probably use a small estate affidavit and they will turn the contents of the box over to me. So that's another thing that you could try. If they won't let you into the box, you don't have a key, you may indeed find yourself in court. And that stinks, but that's just the way life is. A lot of clients, trustees who are my clients or asking me questions, they always wonder about reporting to the beneficiaries. They're like, well, you know, people, and by the way, sometimes the beneficiaries start asking a lot of questions at the beginning. They start to call and they want a copy of this and a copy of that, and they want to direct the process, and they're starting, you know, there's too many cooks in the kitchen at some point. Here's the thing. If you're the trustee, you are generally in charge. Nobody else is in charge. Don't let people bully you around. So, when do you have to report to the beneficiaries? Generally speaking, if you take a look at most living trusts, they say something like annually or quarterly or every couple of times a year. But basically, on reasonable request of a beneficiary, on the termination of the trust, or if there's a change in the trustee, and annually. These are the general times when a report is due to the beneficiaries. Basically, I tell my clients, you know what, don't bother with it unless a trust and a beneficiary asks for one. And if a beneficiary asks for one, you know, a week after somebody died, politely tell them that it's too early and that you will provide them with an accounting in a few months once you have ascertained all of the assets, and assure them that there will be no distributions before an accounting is made to everybody. And then here's a question that I often get: what should the accounting contain? Should I do an informal or formal accounting? Now, if you do a formal accounting, that means you have to go to court. It means that you're going to do a very specialized report to a judge, and this is something that you must hire help with. You must hire a lawyer's office, because providing a court accounting is a very, very unique and difficult thing to do. And basically, the only reason you want to do that is if you're concerned or a beneficiary is raising a stink and you want to get a judge's blessing on everything that you did. Now, What I usually encourage my clients to do is to do an informal accounting. And basically, this is a letter to the beneficiaries, and it says, you know, hey everybody, I'm the trustee. Remember me? I sent you that letter, the 120-day notice. And also that letter should basically say how much money was in the trust when the decedent passed away, what accounts were there, what checks were written, what expenses were incurred, how much is left in the trust, how much you're setting aside for taxes, how much you might be taking as the trustee for your trustee fee, any attorney fees that were incurred. And then at the very end of this letter, you would say something like, you know, proposed distributions would be as follows, you know, such and such amount to so-and-so, such and such amount to so-and-so. And at the very bottom, you want them to sign this letter, this accounting letter to them, indicating that they agree with your accounting, they find it to be adequate and reasonable, and that they release you as trustee from your duties. Which is very nice, because now you have a letter from these folks releasing you from liability, accepting your accounting, and now you can make a distribution to them much more readily and with much more confidence that they're not going to come after you again. I always believe full disclosure is the best course of action. Full disclosure. Let everybody know what you're doing and where the money is going, etc., etc. Getting valuations. There's a lot of assets that might need an evaluation upon the death of somebody. If you're selling the real estate like right away, then don't worry about getting an appraiser, because you're going to have an appraisal during the sale. If you're not planning to sell any real estate anytime soon, or you're going to hold on to it for a while, I would get an appraisal, because the appraisal will affect the cost basis of the property. And the cost basis is going to be used when calculating how much of a gain you made when you sell the property. So let's say you inherit the property and the property is worth $300,000 according to an appraisal's evaluation. An appraiser, you're going to have to get them and you say, listen, we need something called a date of death evaluation. It's called a date of death evaluation. You give them the date the person died, and you tell them that you need a date of death evaluation for this property. And they will provide you an appraisal for that property. And not just this property, you should also get it on any investments as well. Basically, you contact the brokerage or the investment advisor and say, listen, I need a date of death evaluation on all of the investments that so-and-so had. And the reason is that that will provide you with a new cost basis when figuring out taxes. So the example I was giving earlier, let's say you inherit some real estate, it's worth $300,000 on the date of death. It may have been purchased for $100,000, but let's say it's worth $300,000 when the person dies. If you turn around and sell that property for $450,000 a few years from now, you will have to pay gain on $300,000 up to $450,000. You don't start from the $100,000 that was originally the purchase price. You start with the new floor, the new cost basis, the appraisal that you got when the person passed away. And also, you want to be careful. There might have been an A and B trust. An A and B trust is sometimes created when one person in a married couple dies. So if one person died a few years ago, you want to make sure that the trust was not split into two. And if it was, you're going to have to handle both of those trusts. Sometimes distributing things is not the best idea. And that's why sometimes I tell clients, don't be in such a rush to distribute everything. You don't have to resolve everything in 1 week. And the reason is that sometimes a beneficiary may not want what you are trying to give them. For some reason or another, it's not a good idea. They might be getting some kind of government benefit. They might be in bankruptcy. They might be going through a bad marriage and a divorce. The last thing they want is to inherit something at that point in time, because they could lose it. So you want to make sure that people are not going to disclaim any gifts. And there are procedures for that. A person would sign a disclaimer, and that generally has to be done within 9 months of the death. You should get help of a lawyer if you're going to encounter any beneficiary who is disclaiming the asset. And basically the effect of that is as if the person died. So it's as if the beneficiary died before the decedent. And then you have to look at the trust and say, okay, what does the trust say if this person wasn't in the picture? Who is next in line? A tricky part of this also is transferring the real estate. So let's talk about transferring the real estate in most cases. So let's say that the asset is in the name of the trust. The parcel of real estate is in the name of the trust. The Joe Smith Trust, for example. First thing you got to do is you got to substitute the trustee. What does that mean? If you're the trustee, you can't sell this house until your name is on title. So the way you do that is you have to get your name on as the trustee of the trust. And how do you do that? You generally do it with something called an Affidavit of Death. An Affidavit of Death is something you file with the county, and it basically says, hey county, so-and-so passed away, I'm the successor trustee, and I'm in charge. That's basically what it says. I mean, it says it a lot more fancy, but you provide them with a certified copy of the death certificate, and now you are going to be on title as trustee of this property. And with that, you want to file something called a preliminary change of ownership report, because you don't want to be reassessed on property taxes. Every time you transfer property from one owner to another, at least in the Los Angeles County area, you get reassessed on the property taxes, and that might not be a good idea because you could end up paying a lot more in property taxes. So you want to make sure you file this special thing called the preliminary change of ownership report, which prevents you from being reassessed in most cases. Then you're going to deed from the trust to the beneficiary. So now that you're the trustee of the trust, you now have the authority to give that real estate to somebody, or to sell it, or to do whatever you're going to do. If you are going to transfer the property to a child of the decedent, one of the children of the decedent, or even one of the grandchildren of the decedent, you want to file something called a parent-child exclusion. A parent-child exclusion is nice because you get to keep the property taxes right where they were. They don't go up. And this is a special feature of inheriting from a parent or a grandparent. This thing called the parent-child exclusion excludes you from having the property reassessed, and that way you can keep the property taxes at a much lower level. And again, as I mentioned before, if you are selling the property, get an appraisal. The reason for this is because you don't want to be accused of selling the property short. Or, hey, you know, the house was worth $500,000 and how come you sold it for $200,000? We could have gotten $500,000. Well, you have an appraiser's report saying the house is worth X. And it's harder for them to argue that you tried to shortchange the estate or you did a hasty sale when you have a report from an appraiser telling you how much the house is worth. There are also some tax issues that can arise on occasion. Now, this is rare, but one of the questions you got to ask yourself, is the estate taxable? Every year there is something called the exemption amount. The exemption amount is the amount that the government allows you to have without being taxed. Currently, while this is being recorded, that exemption amount was $5 million. However, that doesn't necessarily mean it won't change in the future, and frankly, I would count on it. But you basically have to ask yourself the following question. Was this estate big enough to incur any tax? And if it was, this estate tax, tax return has to be filed, a special tax return. Now, that's something that a CPA should handle for sure. And if it was well below the exemption amount, then you don't have to file that. But the reason you want to take inventory is so that you know whether or not one is required or not. And of course, an income tax return is probably going to be required for the estate one way or another. Now, you may not have to pay any income tax and there may not be much due, but you still have to file one anyway. The trustee has to be fair. This is one of the most difficult things to do as the trustee, trying to be even-handed about everything. You cannot play favorites. You might have a favorite sibling or a favorite cousin or a favorite uncle, but you cannot play favorites, and sometimes you might find yourself tempted to do so. Also, majority does not necessarily rule. You can't just take votes and say, okay, let's just do it this way because we have a vote. You got to make sure, you have to see what the trust says. You see, the trust is a legal document and you have to follow it. It's not just general guidance. It's a legally enforceable document, and if you don't follow it, you can be in trouble. So I've seen some clients say, well, I gave Johnny his money early because he really needs it. Or I think I'm going to give him some more because the others don't need as much and I'm going to give them less as a result. Not a very good idea. If you're playing favorites, or if it seems at all that you are benefiting one person over another, even if that's yourself, you got to be very careful. If you are going to vary from the trust, there's a couple of things that you can do. You can ask the court for permission by asking a judge for instructions about what you should do, or you can get everybody to agree to the new plan. So let's say, for example, you want to do something a little bit different from what the trust says, and it would be for the greater good. If you can get all the beneficiaries to agree in writing that they agree to the new approach, then you might be okay. Again, it's not the most ironclad way of going, but it all depends on the relationships in the family. If there are any minors, sometimes this has to do with people who are not minors, but many of the trusts that I handle call for a sub-trust to be created for minors. So let's say the person passes away and they have minor children. You don't want to give the kids their inheritance right away, especially most trusts will say, you know, keep Johnny's share in a trust until he's 25 or something like that. Whatever you do, when you set up accounts for these folks, for these minors, you want to get a tax ID number for each account. And again, your lawyer or your CPA can help you get a tax ID number for each account. You also want to properly name the subtrust. So it needs to say something like Johnny Smith Subtrust pursuant to the Smith Family Trust dated such and such. Also, another question is, who is the trustee of the subtrust? Now, in many cases, it's the same as the trustee for the main trust, but sometimes the person who created the living trust will say, you know, for Johnny's subtrust, so-and-so will be the trustee. Make sure you read the document and see what it says. Also, make sure you pay attention to any rules of the subtrust. You know, when does Johnny get his money? Is it at certain ages? Is there any other circumstances where Johnny can get his money? Do I make, you know, distributions to Johnny directly? Is there another thing I should be doing? What kinds of distributions can I make to Johnny? So make sure you read that very carefully and get the advice of an attorney on that. And also, you want to make sure that in most cases you're going to be accounting to this on the subtrust, which means that you're going to be providing the guardian of that child with an annual report. It doesn't have to be very complicated, but just a report indicating, you know, what's going on with that subtrust. If there's been any distributions, what were they for, any checks were written, etc. Because, again, it's all part of full disclosure. You have to provide that. In most cases, you got to provide it on an annual basis to the persons who are in charge of the minors. Oh boy, what if people are bickering? This happens in many families. Sometimes not everybody gets along. And again, this goes back to what I was talking about earlier, how you have to be fair. You don't simply give in to the demands of whoever is the loudest. There's always one family member who tends to be very loud, and that person doesn't necessarily have to win every time just because they're loudest. See if you can work something out that is fair. If there is a bickering situation, try to work something out that is fair, and make sure you get everybody to sign off on your resolution. You may also want to go seek help from a mediator. There are people who specialize in mediating cases that involve probate and that involve trusts, that involve estates. These are professional mediators, and a mediator is basically somebody who helps people resolve their problems. And basically all the parties have to agree to the mediator. The mediator is not terribly cheap, but it is sometimes the easiest, most economical way to go, especially if you feel there might be some chance of resolving this matter without going to court. And that is the last option. Hire an attorney to go to court. If there is bickering going on and you're not quite sure what to do and you need some kind of backing, you may ask the lawyer to go to court and get instructions from a judge. And this is known as a petition for instructions. Basically, you're asking the judge, hey judge, what the heck do I do? This is what's going on. These are the ideas that I have. What do you think? And then the judge will issue an order. And now you are following the order of a judge, which gives you a lot more footing than you're just making things up as you go along. Many times people ask me about paying themselves as trustee. They say, how do I pay myself? How much money should I take? The trust usually will say something about compensation. Sometimes it'll say no compensation. But it's been my experience that regardless of whether the trust says that or not, most judges will allow something called a reasonable fee. And this is a little bit of a kind of a subjective standard, but a reasonable fee, at least at the time of this recording, was approximately 1 to 1.5% of the assets being handled per year. So let's just say, for the ease of discussion, that I don't know, let's say every year the trust has $100 in it, just for discussion, just $100. Well, 1% of $100 is $1, and that's how much you get every year for managing the trust. I tell my clients to make it part of their accounting when they write that accounting letter to everybody near the end of the process, where they're basically proposing the distribution. I tell them, look, write down what your proposed fee is going to be and explain to them how you arrived at that fee. Sometimes you can use an hourly wage, like $25 an hour or $35 an hour. You have to find out how much trustees are charging in your neighborhood. These are professionals, and then charge less than they do, because they are professional trustees and you are probably not. Generally speaking, professional trustees pay themselves about double what a regular trustee would be allowed to take in a hourly fee. But again, you're going to have to ask yourself, if I charge $200 an hour, that's probably not going to sit very well with the beneficiaries. But if you charge $25 an hour, $30 an hour, I don't think anybody's going to have a huge problem with that. Sometimes a trust will say no fee. And frankly, if it says no fee, you might want to think about resigning. This is a lot of work, folks. Being the trustee is not an easy job. And if it says no fee and the beneficiaries are going to give you a hard time, unless you really, really want to do this job, I might consider resigning, and the next person named in the trust would step in for you. And the last thing on our list here is the hourly fee, which we've already discussed. When it's time to make distributions to everybody, I would get everybody to sign the accounting letter that you sent. Remember, I talked about the informal accounting where you tell everybody what happened? I would get everybody to sign that letter, get them to release you from liability, and when you give them the money, ask them to sign a receipt that they've received that money, so you don't get any monkey business later on of somebody saying, hey, I never got that money. And of course, I alluded to this before, but you want to keep a reserve in the trust. Keep some money in the trust, because you don't know if there's going to be a surprise bill, if there's going to be taxes owed. And talk to a CPA about that. Ask them, gee, how much money do you think I should leave in the account? And tell everybody how much you're going to be leaving in the account. After the storm has passed and you find out that you don't owe any taxes, or you've taken care of all the taxes, and you're pretty comfortable that there's no further bills that are going to pop up out of nowhere, then you can go ahead and distribute the final amount according to the instructions of the trust. I hope this has given you a nice overview of what to do when handling a living trust. I know it might seem overwhelming, but hopefully this information gives you a little bit of a nice list of the kinds of things that you'll have to be thinking about. Again, this has been Robert Mansour. My office address is located on the screen. You can call me at 661-414-7100. The website is mansourlaw.com. And as I said before, this video is not a do-it-yourself video telling you exactly what needs to be done. Again, I always think you should hire professionals, both in the legal field and the financial field and tax field, to help you navigate these waters. It's kind of like getting in a riverboat without a guide. You really should have a guide there, at least somebody you can consult with along the way. You might be able to do some of this on your own, and that's fine. But it would be a good idea to cover yourself and get financial and legal assistance. This video is primarily designed to give people an overview, a to-do list, if you will. Again, I hope it's been helpful. Again, my name is Robert Mansour, and I really appreciate you watching. Take care.